Good morning. Raise your hand if you have anything to do with Vermont Law School. Okay, I just want to see if you're awake and listening. I'm Tom McHenry. I'm the Dean and President, and it's just a real honor to be up here and open up these proceedings. The very good news is that I'll be blessedly brief, and my main job is to introduce Jenny Rushlow, is to my left, who is our new ELC Director. But before I introduce Jenny, I want to tell you that the topic that you're looking at is a really important one. When I was in private practice, I spent a bunch of time advising corporations on compliance with climate change disclosure issues, talking to people about climate change issues, and whether you like it or not, whether or not we can change it in different ways, corporations play an immensely strong and important role in our society, not just in the United States, but globally, a subject of much interest for the development of our entire planet. So I think you have a great group of speakers today. It should be very engaging. Thanks to Pat and Angela and so many other people who've been involved in organizing this. Pay attention. I think it's a great topic, and enjoy yourself while you're here. So I want to introduce Jenny Rushlow, and I'm particularly delighted to do so because she is the new head of our Environmental Law Center. By the way, I got to spend a few minutes yesterday with David Mears, who left us as the Environmental Law Center, has become the head of Audubon in the state of Vermont. We were up at the Vermont Community Foundation. He sends his best, and we are looking for some cooperative projects between Vermont Law School and Vermont Audubon. She'll be fun. Jenny started this Monday. We have been waiting, and the stack of email messages she has had and projects we have to talk about with her is huge. She has thrown herself into the fray right away, as we knew she would, and she is living down in where I live in Norwich, Vermont, which is terrific. She was formerly a senior attorney and director of the Farm and Food Project, which is a New England-wide advocacy program on agriculture and food issues with the Conservation Law Foundation. I had one of her colleagues come up to me yesterday at the Vermont Community Foundation meeting and say, well, our great loss at Conservation Law Foundation is Vermont Law School's gain, and that's certainly the way we think about it. Jenny is a litigator. She's developed projects, and she's been a passionate and effective advocate for equity and justice. In 2016, she argued and won the landmark climate law case before the Massachusetts Supreme Judicial Court. That's the Kain case, K-A-I-N, for which she was named 2016 Massachusetts Lawyer of the Year. She's also developed the Legal Food Hub when she was at the Conservation Law Foundation, and her interests lie, and when you hear these interests, just think about all the things we do at the ELC, the Environmental Law Center, acronym doesn't mean something to you, which involve clean transportation. She drives the new Prius Prime, I think, which I had my eyes on. Electric vehicle policy, renewable energy policy, land use issues, and she taught a food policy course here at Vermont Law School. She holds a JD from Northeastern School of Law, a Master's of Public Health from Tufts, and a BA from Oberlin College. Introduce Jenny Rushlow. Thank you.
Thank you, Dean McHenry. It is so great to finally see all of you. I'm delighted to be here at Vermont Law School. As Tom said, I've been in Boston and practicing as an advocate since I graduated from law school a while back. And I've always considered Vermont Law School to be a treasure among law schools. This is a truly special place. I considered my time at Oberlin in college to be a similar kind of experience, being among people who are truly passionate about what they're going to do with their lives. And I've already seen that, been so impressed with the students dropping by my office, have already had office hours yesterday for the first time, and hearing about the true passion and motivation to do things with what you're learning here in law school. And that's how I felt in law school too, and I'm thrilled to be working with people who are like-minded. I'm also really excited about the offerings that VLS has in the environmental sphere. VLS remains a leader in environmental law, has more course offerings, more clinics, more programs and certificates than any other law school out there. There's tons of meat to dig into when it comes to environmental law at Vermont Law School, and I couldn't be more delighted to work on that full range of issues with you all. Climate change is particularly close to my heart. As Dean McHenry mentioned, I spent several years working on a big climate change case in Massachusetts, and that was enforcing the Global Warming Solutions Act, which is a state statute in Massachusetts that ratchets down greenhouse gas emissions year by year. And so the notion of how corporations interact with climate change and the regulation of climate change is something that I've spent a great deal of time thinking about. And you will too, if you're moving into the field of environmental law. And frankly, I don't think you can be a practicing lawyer and not have climate change affect your world in some way. Particularly in this time of rapid deregulation of not just climate change, but all environmental issues, how corporations approach climate change is really at the epicenter of environmental law and environmentalism at this moment in time. So this topic could not be more important. I'm thrilled that you all are taking the time to really dig into these issues, and I'll be glad to join you for as much of the day as I can. So I look forward to getting to know all of you. Great to be here. With that, I'm going to turn it over to Patrick Leary, who is the editor-in-chief of the Law Review.
Hello, everyone. Good morning. Like Professor Rushlow said, my name is Pat Leary. I'm the current editor-in-chief of Vermont Law Review. First thing I would like to do is thank Serena Tang and Angela Sicker for their hard work and dedication in organizing today's event. Without their vision, today could not have happened. I would also like to thank each and every member of Vermont Law Review that has helped with the final touches and basically made Angela and Serena's vision a reality. The Vermont Law Review hosts this annual symposium to examine issues that are near and dear to our members' hearts. This year, we seek to examine the roles that corporations will play in crafting solutions to the environmental problems that we face as a society. We often hear that you can have either economic growth and prosperity or a clean environment. Today's discussion will hopefully show that this is just a false dichotomy. The panelists will explain creative solutions that they have found in their practice, and while there is no silver bullet, we hope that this day will encourage you to enact some of their ideas in your careers going forward. On behalf of Vermont Law Review, I'd like to thank everyone for being here and welcome you to this year's symposium, Corporations and Climate Change. Professor Scanlon of the New Economy Law Center is going to come up and say a few words, but I would be remiss if I didn't take this opportunity to thank her for the help that she's given Law Review and Angela and Serena in organizing this event. So thank you, Professor Scanlon.
All right, we've got a whole slew of 1Ls sitting out in the hall. They should be coming in soon. Thanks. Thanks for the opportunity to the Law Review students for inviting me to co-sponsor this through the New Economy Law Center. It's been delightful to spend several months working on the program that you all have before you. So today we're gathering here in Vermont, but meanwhile in California, leaders are meeting at the Global Climate Summit. And although we're not an official side event, we are aligned in intention to find solutions to accelerate our abilities to stem global climate change. Just this week, we heard from the UN Secretary General that warning about the risks of runaway global warming if we don't change course by 2020, it's 2018, and called on the global leaders now to rein in climate change even faster. Of course, we're not seeing that at the national level in the United States right now. And so people are turning their attention to states and localities, but they're also turning their attention to the private sector, which is why we decided to put together this symposium at this time on corporations and climate change, to focus on the climate, on the private sector. Of the top 100 economies in the world, over 60 of them are corporations. So if we're going to do something about climate change and do something that radically alters how we have this economy wired, off of fossil fuels and onto renewables, corporations are going to have to be at the center of that. And in fact, they have been at the center of the destructive forces of climate change. The emissions of the oil and gas industry collectively account for approximately half of the global carbon dioxide emissions. And if business as usual continues, we're on the path for a plus 4 degrees Celsius world by the end of the century. Obviously, that would be catastrophic, not only for humans, but for all species. So we need to keep fossil fuels in the ground. And what is the role of corporations in creating this catastrophe? I think we see it. We're going to learn about it in the first panel. But then we're going to shift our attention to the majority of the day is going to be focusing on corporations as innovators and problem solvers. So this isn't going to be just a doom and gloom kind of day. We'll take an unvarnished look at corporations in the first panel and what they've done to contribute to climate change. And then we'll move rather quickly onto how to harness the power of corporations to solve this massive problem for all of humanity. So we expect that you're going to hear an array of solutions, and we're hoping that this is going to spark discussions among you, and that you'll engage with the panelists, and that the discussions will continue out the door beyond the symposium, and that you'll have new ideas for going forward into being problem solvers as you too work with corporations in your future. So enjoy the day, and thanks for being here. I'm now going to welcome our first panel to come up, along with our moderator, Professor Mark Latham.
Good morning. I want to thank you all for joining us at today's symposium, which the Vermont Law Review is hosting. I'm Mark Latham, and I'm on the faculty here, and I teach torts, business associations, and of course a couple of environmental law courses. But I'd like for the members of the Law Review to stand, please. Come on, don't be shy. But I want to acknowledge them again for all their hard work and the immense number of hours spent on planning today's session. And I'm certainly pleased and honored that they asked me to moderate today's first panel. Now, this summer, we all witnessed raging wildfires in California and elsewhere. There were deadly heat waves around the globe. And as we meet here this morning, a massive hurricane named Florence has just started to wreak havoc on the Carolinas. And tomorrow morning, it's anticipated that a so-called super typhoon named Mangkhut will strike the Philippines, specifically in Luzon, which is a major center of food production for that country. Now, these and other so-called natural disasters have all been exacerbated by the increasingly higher and higher levels of carbon dioxide that we have in our atmosphere. Those increasing emissions of carbon dioxide are largely due to the burning of fossil fuels for transportation and energy. Now, meanwhile, as we all know, the Trump administration is aggressively moving to eviscerate the modest efforts of the Obama administration to reduce carbon emissions, and has also essentially walked away from all international efforts to address climate change. So it's a lack of leadership in Washington, as well as a lack of intelligence at the federal level among the members of the Trump administration on this issue. Where else can we look to for guidance, the leadership, the resources, and the will to make a difference and address what is really an existential threat to, indeed, humankind? Well, what about the business sector? What has it done or might do or should it do to address this problem? And that's what we're going to begin exploring this morning with the panel. Now, with me to help do that is Professor Richard Walsgrove of the University of Hawaii. Now, last night at dinner, I started to ask him, if this were held in January, would he join us? And I figured that was an unfair question because no matter what he said, if he said yes, then we would know he's crazy. And if he said no, then I would have been insulted, so I didn't ask him that. But welcome from Hawaii. Then Lisa, Dr. Lisa Benjamin, who's from Penn State, right? But I think I heard you over dinner last night mention that you were also from the Bahamas. Is that right? So I would have asked you the same question, but again, I declined. But welcome to you both. And then Ben Crass, who I didn't meet, but thank you for joining us at the last minute because a colleague of his had a last minute conflict, and so he's was kind enough to join us. And then Brian Dunkill, who's at the far end of the dais here, he's a VLS alum, a graduate of the class of '96, I believe, and one of the founders of a really top-notch firm here in Vermont that does a lot of cutting-edge environmental work, and that's Dunkill Saunders. Now, Brian has graduated years ago, but he hasn't forgotten Vermont Law School, and he's served on the Board of Trustees for a number of years. And we also co-chaired, a year and a half ago, the Dean Search Committee, where we rescued Tom McHenry from a life that consisted entirely of 6-minute intervals as a lawyer in a large firm in Los Angeles. So welcome to all our panelists. And now the format for today is that each of our panelists are going to speak for about 15 minutes, and then which should take us up to about 11:45. And then from 11:45 to 12:45, there'll be time for questions and comments, and we hope a dialogue about this very important issue about what can corporations and other businesses do to address climate change. So with that, Richard, thank you very much.
Thanks very much, Mark, for getting us started. So first things first, if I end up fouling up my use of the microphone, the back row needs to raise their hand and scream and shout. Deal? Okay, thumbs up. I'm delighted to help kick off this panel, what I think will be an interesting discussion. I want to start with 3 warnings to you. The first warning is that the title of the panel uses the word disruption, right? Climate disruptors. And I think we need to recognize that phrase, disruption, actually comes in 2 flavors. There's the bad connotation. We're talking about entities responsible for disrupting the natural climate cycle. But in the context of business, we often also use disruptive in a good context. We talk about disruptive businesses, which actually are markers of change and progress and coming up with new and better ideas. So I want to warn you, I'm probably going to use that word in both contexts. You're going to have to figure out what I'm talking about as we go. Which leads me into my second warning, and that is I have a struggle today. I'm going to talk about a topic, and I know there are folks in the audience, I know there are panelists and there are faculty members who know this topic better than I do, and they will leave this 15 minutes saying, well, you haven't said anything. I know there are those of you out there who have no idea what I'm talking about, and I have to, in 15 minutes, teach you what I'm interested in so that we can have a discussion about it. So the result is everybody is going to be disappointed after 15 minutes, and if I've done that, I actually will consider I've done my job well. My third warning, and then we can finally start, is to let you know I'm wearing my VLS socks, which I have to thank the law review for giving to us. Julius is wearing the same socks. I already feel comfortable, so even though I'm going to confuse or disappoint most of you, I'm feeling good about it. We can get started, so long as my clicker works. Or I should say, so long as I know how to use my clicker. Aha. And the microphone. Dicey. Okay, so I'd like to tell you a story, is what will happen today. And my story proceeds in 3 parts. First, I want to talk to you about the solar industry and the development of new business models. And I'll use Hawaii as an illustration, but I think it's applicable in other places. I know it's applicable in Vermont. Second, I want to switch and talk to you about securities laws. And so another word of warning about phraseology here. When I say the word securities, I'm not talking about national security. I'm not talking about locking the doors. I'm talking about securities in the context of stocks and bonds and investment contracts, something that I know lots of you know lots about, but some of you need to probably take business associations with Professor Latham before you know what I mean. And then finally, I want to switch and tell you, once I describe how I think these 2 topics intersect, where I think this might be headed. With that, I'll start with my promised solar story. The solar story in Hawaii has been phenomenal. About a decade ago, the rooftop solar industry didn't exist. And then we had a growth period, about 6 years, where the capacity of rooftop solar doubled every year. I mean, that is the very definition of exponential growth, and it's been remarkable. At the peak of that boom, the solar industry, this brand new industry, was responsible for 30% of all construction expenditures in the state. Construction is actually one of Hawaii's largest industries. So this was a remarkable economic shift due to innovation in the private sector. At the same time, over the course of roughly that 10 years, we've seen a 30% decline in our consumption of oil for electricity generation, which has obvious implications for climate change and our greenhouse gas emissions. And then finally, I think the recognition that we're actually changing our relationship to electricity and energy. When you consider that 1/3 of all single-family homes now have solar panels on their roof, and people that used to be electricity consumers are now electricity producers. And this, for us energy wonks, we actually have now given them a new name. We call these people prosumers. And so really changing the dynamics of lots of pieces of our economy with rooftop solar. What some of you caught and others of you perhaps didn't is that there was a caveat in that description, and I said that 30% of single-family homes have solar panels. But I live in a place where roughly half the population lives in multifamily dwellings. So you can imagine these buildings at the back here. This is where half the population lives, and almost none of those folks get the benefit of this solar boom. They don't get to participate in it. And the response to this has been a smart one, the idea of something that I'll call community solar. Sometimes it's called shared solar, sometimes it's called neighborhood net energy metering. Community solar is a simple concept. The idea is you don't have to have a roof to have a solar panel. You can put your solar panel anywhere on the grid, and we can use accounting to just say, hey, I can credit that generation against my electricity bill. So that's my definition of community solar. I know some of you will have slightly different definitions. I also want to say that I have a particular vision for community solar. It can exist in lots of different forms. In my vision, I like the idea of community scale community solar. So this is where existing communities and networks would develop a project in their community that's sized to their energy needs. There are lots of reasons we don't have time for today. I can describe to you why I like that particular vision. One of the reasons is I think it comes up with a new way to do brownfield solar development, which is something we're just not very good at the moment in Hawaii and elsewhere. So here's my vision of community solar, and I had to define all that for you in order to get to securities. And what does security laws have to do with community solar? Well, that story starts with the admission that my vision for community solar is not everybody's vision for community solar, and that came up in Hawaii and other places in the form of designing this program. This is a regulated program, a regulated concept. To design it, we had to go into a docket before the Public Utilities Commission, and in that docket, the Hawaiian Electric Companies, that's our largest utility in the state, an investor-owned utility, traded on the New York Stock Exchange, they described a vision that was utility-centric for community solar. It was also utility scale. This would be big. They would run it. It would be very similar to the existing procurement mechanisms. And part of their argument in advocating for that particular vision for community solar was, hey, if you allow this more flexible community vision for community solar to win out, there's the risk of securities penalties. This is the Securities and Exchange Commission levying penalties against the utility on the order of $250 million with a B. So that's a big deal. That's a big deal because if the utility gets hit with penalties, who pays for it? Raise your hand. We all do, right? We all pay. The utility doesn't go out of business. We all pay for electricity. So what they're saying is we're going to pay for it if this vision of community solar wins out. And I should also say that $250 million number, that was the conservative number. They said at the upper end of the scale, it would be $1 billion in penalties. And this is $1 billion for the first phase of community solar, which is just 4,000 or 5,000 participants. I have never in my life, never in my practice, seen quite such a bombastic parade of horribles trotted out in argument of something. But it actually carried the day. It didn't carry the day in the design of the program, but the narrative is that the securities issue is real. We have to deal with it. We have to address it head on. Hawaiian Electric companies didn't make up that argument. They actually cited an order from the California Public Utilities Commission, which had imposed fairly draconian securities rules on community solar developers. And the California Commission didn't make up the argument. They cited to this 2015 report from the National Renewable Energy Laboratory, in which some folks, some stakeholders, at least one of whom is on a panel today, so I'm excited to hear some feedback on this. One of the stakeholders, a number of the stakeholders expressed real concern about the impact of this securities question on community solar. I was fascinated when I read this and actually leading up to it, because what we see is this big, thorny, and hairy legal question for something that I think is pretty important, coming up not from a sort of a well-defined legal dispute, not because some regulator has made a decision or a court has made a decision, but this is just people thinking about, hey, what's to come? And I thought to myself, well, this deserves more research. And so what do you do when you're not sure if something is or is not a security? You look up the definition, and we're all lawyers and law students, so we can do that. I thought this was going to be easy, right? Well, there it is. There's the definition. Please read it in detail in the back especially. The federal securities laws and most of the blue sky laws, that's what we call the individual 50 state securities laws, they've all adopted a laundry list definition for a security. And in fact, there's a catch-all at the end of it that says anything commonly known as a security is a security. Thank you very much, drafters. That's very helpful. I appreciate it. It turns out there's a robust history of interpreting this definition. The legal hook is the phrase investment contract, and we have a long history of the U.S. Supreme Court actually making a test for what is and is not an investment contract. It's called the Howey test. It's widely adopted. It's the majority test for the blue sky laws as well. It's a 4-part test, and I won't go through it today, but this is the test most of these descriptions about the securities issues in the community solar context have used. Just to illustrate to you some of my confusion for why this was getting so much attention, the only definitive determination that I'm aware of today about whether an investment in a community solar project is or is not or a security or involved, whether or not the transaction involved a security, comes from this 2011 no action letter where the SEC told some folks who are developing solar condos, it's community solar by another name, they told them, we're not going to take any action on this. It doesn't seem like it's a security. They applied the Howey test. But others disagreed. Here's an example from Vermont. Vermont's financial regulators have actually issued an exemption, I think a fairly narrow exemption. It sounds like not a terribly useful exemption, but an exemption nonetheless for some community solar projects. But in their order to justify that exemption, guess what argument they had to make? Under the Howey test, community solar is very likely to be a security. And so you're left with uncertainty. And let's think about how this uncertainty works. If I'm a big utility, especially a publicly traded one, or let's just say I'm even a reasonably large renewable energy developer, I have lawyers. I can deal with this uncertainty. I can figure out how to either not be a security or how to design around it. But if I'm a small community group who wants to develop, 30 panels on top of somebody's parking lot, that's a much bigger burden. And it's a much bigger burden not just in the uncertainty context, but it's also a burden. What if you determine, hey, I am a security? I have to now register. That's really expensive. I have to deal with all the anti-fraud provisions. I mean, this is actually, I think, could be path-defining for community solar, answering this question. And we live in what is turning out to be, I think, paralyzing uncertainty on this topic. Well, I'm here to tell you the problem is even worse if you're not in Vermont or one of the Howey states, because that's just the majority test. The minority test, which gets almost no discussion so far in the debate, is called the risk capital test. 16 states and Guam use this risk capital test. Some important states, California, the largest community solar market in the country, which today has 0 megawatts in the ground. Hawaii, where I'd argue we probably have the sort of biggest potential for community solar to make up a big portion of our generation mix, and a bunch of other states that I could all argue to you are important for community solar are dealing with the risk capital test. Which takes us right back to Hawaii, because the risk capital test actually comes from, in large part, Hawaii. A case called the Hawaii Market Center case. It's the most commonly sort of enunciated version of this risk capital test. It's another 4-part test for what is and isn't a security. And most folks will tell you, I think if they haven't looked at it too closely, that the 4-part definition is broader than the Howey test. So if you're a security under the Howey test, the logic goes, you're definitely a security in risk capital markets. I would love to spend all day telling you about why I think we can win on this issue. This is a 4-part test. If on any one of the 4 we win and say it's not a security, it's not a security. We don't have time to go through all 4. But the one that we might think about a little bit is this idea that securities involve transactions where the investor, and I hate that phrase, but that's what we'll use because it's the one usually used, where the investor exercises no control over the transaction. So a passive investor, somebody who invests in Apple stock, right, that kind of investor. Well, community solar is not like that at all. In order to get the benefit, the economic benefit of community solar, you have to have an electricity bill. In other words, you have to consume electricity. If you don't consume electricity, you don't get the benefit of your generation. And I think there's a line of cases, which I haven't seen cited anywhere so far, that would suggest this actually might control the outcome, that this measure of control over the economic value stream actually gets us out of the risk capital test. By the way, the argument works in reverse. If I win under the risk capital test and it's broader than the Howey test, I should also win under the Howey test. So I think the risk capital test and the blue sky laws is where all the action is, and yet it hasn't really been discussed. Which is why I'm really, really interested in it, and I'll talk to you about it forever and ever and ever if you let me, but you won't. Julius tells me I can go for 2 more minutes. So in 2 minutes, I will just tell you one piece of this. I have now spent hours of my days, months of my life tearing this apart from every possible angle to either convince myself on one side or the other there is or is not an issue here. And one of the angles that I think is just interesting is that the very first court in the country to use this phrase investment contract and to interpret it was the Minnesota Supreme Court back in 1917 in this Gopher Tire and Rubber case. It's a case that's still cited today. It's cited in Hawaii Market Center. And in that opinion, they say the reason we have blue sky laws, the justification for the securities laws, is to stop things like investments in visionary oil wells. And I saw that phrase, and that's like catnip to me. I had to figure out, what do they mean? What's a visionary oil well? So I spent days and days and days and days going through the Minneapolis Star-Journal in the early part of the last century, and I found advertisement after advertisement for money-back, guaranteed, no-risk investments in oil wells in Minnesota. So I kept digging, and I went back. It turns out 20 years before that decision, 25 years before that decision, the Minnesota state geologist had already issued a report saying you're not very likely to find oil and gas in Minnesota. So we stand here today, it's been 100 years. How many commercial oil and gas discoveries have they had in Minnesota? None. It hasn't happened. The point is, I think that Minnesota's Supreme Court's skepticism about this was pretty justified in 1917. But if I look at the modern headlines, here's one from Hawaii's business newspaper. Our headlines, our context for community solar is pretty radically different. And so I think we need to spend some time going back into the history and thinking about this. The headlines in Hawaii, for those of you who can't read it, are, we're having some trouble finding developers to do community solar. One of the reasons is this uncertainty about the securities issue. Okay, so there you go. Now Julius tells me I've got 30 seconds, and lucky enough, that's exactly how much time I planned for this last piece of the story. Looking ahead, where do we go? I think some pretty massive mistakes have been made in how this issue has been raised and presented and the narrative that's been developed about it. So I'd like to start with suggesting we reframe the narrative. If we go back, the architects of the securities laws are some pretty famous folks: Felix Frankfurter, Louis Brandeis, William Douglas, those kinds of folks. If we go back, they were talking about protecting orphans and widows. And in my mind, the last century's orphans and widows are next century's climate refugees. And so the climate refugee context might get us thinking in a whole new frame on this issue, the energy justice frame, which is something, if you are a 1L or a 2L or 3L, I think you should go and read about, but I won't tell you about today. But the idea is there's a new way to think about energy and how we provide energy, and this might actually reframe the way we do corporate governance in this context, which would include the securities laws. With that, I will conclude, say thanks for the socks. Thank you, Mark, and I look forward to the discussion.
I want to correct something. I think I said in my introductory remarks that we were going to go from to 12:45. We're going to 11:45. Where's Sarah, right? Right? 11:45, and then we'll break. But now I'd like to bring up Dr. Lisa Benjamin, who's going to provide an international perspective on this issue. So thank you very much.
Okay, I have a technology issue. I don't know how to get to my slides. While that's being fixed, I want to thank Angela and Serena very much for inviting me and for the law review students for putting on this conference. It's great. I started my thesis in 2014 looking at the interactions between corporations and climate change, and so having now conferences just discussing this is really exciting, and everyone's been really welcoming, so thank you for having me. It's okay. I have the socks. I'm not wearing them. I'm sorry, but I'm really grateful for the socks. They look really comfortable. So thank you very much. Am I supposed to be doing something? Oh, okay. Yes. That's okay. Yeah. That's okay. That's okay.
While we wait, are there any questions or comments?
Yes.
Presentation?
Should we do that?
While we take a little commercial break here. So I'm curious, how did you become interested in this issue, the intersection of securities laws and solar? Which is, for me, pretty fascinating.
Does this work? Yeah, it does. I became interested in this as a client, not as an attorney. So I was working with a nonprofit, and we developed a crowdfunding platform for energy efficiency, nonprofit energy efficiency. And because I had taken business associations and paid attention, I actually recognized that there might be a securities issue. We went to the best lawyers in town, we asked the question, and $25,000 later, we had no good answer. And so we actually forged ahead. We thought, well, penalties, we've got no money, we're a nonprofit, let's not worry about it.
Yeah.
But it was the first time that I sort of got introduced to this and how it could intersect some of these community scale energy projects. And then it's popped up. It's now, I think folks in the audience who have been involved in this, it's actually sort of the dominant narrative in community solar debates. And California's decision is remarkable. California has decided that all community solar projects need to come to be shortlisted before selection in the procurement process. They need to come with an opinion letter from an AmLaw 100 law firm, which is way more than $25,000, right? Which says you've complied with the securities laws. They're relaxing that. I think there's an effort to keep relaxing it, but it has sort of emerged as this big, thorny problem. And what I didn't say is that there's a mistake in the way this has been set up. And Hawaii is the perfect example. There's a really well-meaning guy at the State Energy Office who, while we were designing the program, asked the securities regulator to come get involved and, hey, what do you think? Which we as lawyers know, how you ask the question predetermines the answer many times. We shouldn't have done that. And the same thing happened in California. I guess the same thing is happening in other places. Nobody has set up with here's why this is not a security. Here's why it either isn't or shouldn't be regulated in this way. And so that's the type of issue that fascinates me. That's why I've spent so much time on it.
Well,
Go ahead. Yeah.
Okay.
Thank you.
What would a symposium be without a technical glitch or two, right? I mean, you should see me in class with this stuff. Oh my God, this is my students would tell you. I doubt it seriously, or that's very sad if it's true.
So Patrick has a question.
Oh yeah.
Has there been any movement on the national level to encourage the SEC to take an enforcement action, to have a test case, and have an official opinion on community solar?
So Pat's question is, has there been any movement at the SEC to have a test case as to whether community solar is regulated by the federal securities laws?
I wish I could get an answer to this, because as you ask the question, and I've asked lots of developers and lots of securities lawyers similar question, and I get such a wide range of answers, all the way from the SEC does not care, particularly they don't care about these small-scale projects. They've issued the no-action letter. When I tried as a client to get a no-action letter out of our state securities regulator, they wouldn't issue it. And the reason they wouldn't issue it is they said, this is definitely not a security, so we won't give you a no-action letter saying it's not a security. So I think that folks are legitimately or smartly skeptical of going through some of those processes. In part, I think what we're seeing is the climate disruptors not interested in getting the right answer. I was always fascinated that the Hawaiian Electric Company said, hey, there's $1 billion worth of penalties. And during the next legislative session, they didn't ask for any kind of exemption from the state securities regulations. I think that tells you a lot about sort of where this argument's coming from. And then we also need to recognize the SEC actually doesn't necessarily give us the answer. If we're worried about blue sky laws as opposed to the SEC acts, then we'd have to get all 50 states to deal with this issue, which is why another reason I find it an interesting problem is there's a sort of a thorny answer. The SEC, way back in the 70s, issued a pretty comprehensive no-action letter for what they call condo-tels, this idea of where you have condominium units and hotels. And that was actually market-defining for that particular industry. It's huge in Hawaii now, the condo-tel industry. That unlocked it. So I think there might be a reason to get a no-action determination, but it would have to be more than just on a specific transaction. We would have to do beyond. It wasn't a test case in the condo-tel context. It was, give us a mega no-action letter about this into the future. And that is what we need, because community solar is just the tip of the spear to a larger sort of transactive energy economy. Another reason I'm interested in it, I think that we will see this come up again and again and again. We've seen it in the Bitcoin context. I think that we need to think not just about my vision, Walsgrove's vision of community solar that nobody cares about. We need to think about where is this headed over the next 40 years as we address climate change.
Well, I have a suggestion on how you can get a no further action letter. I'm from Chicago, and I think that what I would do is schedule another meeting. And I would start with about $5,000 in cash in my briefcase, and then you go in and see the regulator, and then be prepared for a little negotiation. But I think sooner or later you'll reach a price and you walk out with your letter. Simple. Now you may go to jail, but that's a sort of thing of the day. Okay, take two with Lisa. So come on up. Thank you. Sorry about the
Okay, thank you. I'm back. Is this going to be a time penalty, Julius? Do I get my time? Okay, great. Thank you. Thank you for that. Thank you very much. Thank you again for inviting me and having me here. The piece that I'm working on at the moment is actually about litigation. So I'm not going to cover the U.S. Litigation, which I think Ben is going to cover. But I'm interested in this sort of corporate trend in litigation that's happened really in the past 12 months. And so the title is How to Eat an Elephant, which is a management term, actually. And it's all about how do you approach a really big problem? And the answer is bite by bite. So I'm really interested in the pieces of litigation that have been brought against carbon major companies, which is a really new turn in litigation. Normally for climate change, you'll have litigation against governments. But now we have a series of pieces of litigation that are actually not only by governments against corporations, but by individuals against corporations, specifically in the context of climate change. So I think it's a really interesting development. And what I'm really interested in looking at is this shift. So they're not all going to be successful, particularly in the U.S. context. There are a number of hurdles, mainly because of causation issues. But my thesis is that even if they are not successful in court, there are some indirect implications that are going to come out of these pieces of litigation, particularly in relation to raising the risk profile of climate change for carbon major companies, which hopefully will translate directly to the investors in these companies, and really sort of exposing the role that carbon majors have played in climate change, and also sort of giving climate science its day in court, basically. So the courts have become much more friendly towards climate science, and climate science has really developed in leaps and bounds in the past 10 years, which I'll talk about a little bit. And it's because of the ability of science to pinpoint specific actors and the liability of specific actors, corporate actors, in the role of climate change is, I think, motivating these pieces of litigation. So I think it's opening up different legal avenues, and I look specifically at corporate legal avenues in terms of company law and how company law could be used more successfully in relation to climate change, because traditionally it has not been used. And it's mainly this guy, Richard Heedy. He's from Colorado. I love this picture of him. He wrote one paper, and it's his website is called carbonmajors.org. And basically this paper has been explosive. It has really broken open the ability to bring litigation against corporations. And what he did was he tracked the role of carbon major companies, 90 state and investor-owned companies. And he tracked the role of these companies in terms of their emissions from 1854 to 2010. And he pinpointed the fact that these companies are responsible for about 63% of all all historic cumulative emissions, and being able to track those as a group of corporate entities, but also he was able to do it on the individual scale. And the company, it's a great website, but the company that I want to focus on is RWE, because that is very important in relation to a case that I'm going to talk about. And so Heady's work has really been groundbreaking. I used it in my thesis, and people have built upon his attribution study. So I'd encourage you to go to the website carbonmajors.org. It's a really interesting piece. So when I was doing my thesis, mainly in the UK, in the international context, I was looking at corporate law and figuring out, well, where's the role of the law in all of this? Climate change is a huge existential crisis. What is the law doing about this? And basically my answer was not very much or not enough, specifically in the corporate law context, because company law focuses mainly on shareholders, and that is the stakeholder that is most concerned about. And so negative externalities really get pushed to non-corporate law. And so it's environmental law that deals with it. But there's a very powerful norm in corporate law called shareholder wealth maximization. It's exactly what it sounds like. So basically you work, all of corporate law is focused on short-term profits for shareholders, regardless of the long-term implications of that. And obviously one of the long-term implications is negative externalities. And so corporate law in and of itself is not well placed in terms of its normative theoretical groundings for dealing with climate change. And environmental law, I looked at human rights, I looked at fiscal incentives in terms of carbon taxes. They are not strong enough at the moment to really subvert this. So shareholder wealth maximization is incredibly powerful, and it's really pushed corporations to externalize negative externalities like greenhouse gases. And so I looked at a number of the sustainability reports of carbon majors over time, and what are they saying about climate change? So you see a shift over 10 years. So basically they're now saying, yes, climate change is real, yes, it's an issue. But Shell is a really interesting reporter in that they have an external committee that looks at their reports and basically gives critiques every year on what they are saying. And this critique I love from the external committee that says, okay, you're talking about climate change in your report, Shell, but you're not really clear about what you're going to do about climate change. Are you actually transitioning your entire business model to deal with climate change and renewables, or are you just sidelining it? And that question has never been answered by these carbon majors because there's a deep ambiguity in the way that they deal with climate change. They have to recognize it, but they're not actually really dealing with it. And so I actually think that some of the litigation is raising the risks of climate change, and that could actually be a motivator, even if they're not successful in terms of shifting these companies. Climate litigation, there's been a lot of work on climate litigation in terms of governance, and it's an interesting regulatory tool because law in of itself is at very different levels. So you have the national, the subnational, the local, but litigation sort of moves in between them and is able to create these pathways in between them. And it's also very international for multinational companies. They have footprints in lots of different jurisdictions, and courts in different jurisdictions could take very different approaches to climate change. They could take conservative approaches, or they could take very progressive approaches. And so in that sense, multinationals are vulnerable to different jurisdictions, although I'll talk about parent companies a little bit later on. But climate change in and of itself is very disruptive. So the law seeks stability, and climate change is very disruptive. It is polycentric, it's uncertain. The law is really struggling to deal with it. And so I think climate litigation is a really interesting phenomenon in terms of governance. So there's been a very successful case in Germany in principle, and this is a farmer, Mr. Luia, and he lives in a small village in Peru, which is underneath a lake. And he sued in Germany a utilities, RWE, on the basis of Richard Heady's work, and said that this carbon major has contributed to the impacts of climate change, which are increasing the volume of this lake, which is going to have glacial outbursts and which is going to flood my village. And therefore, I'm suing you, German electric company, for a percentage of the adaptation costs of trying to raise the dams and prevent this destruction. And the adaptation costs are the precise percentage of Richard Heady's calculation that RWE contributed to the historic emissions to climate change, 0.47%. And so they used Richard Heady's work to directly ask for adaptation costs. And they were successful in principle. So they're now going to the damages phase. But it's really the first case that has ever been successful against a carbon major company. So it's very exciting. And so basically they use this concept of not just the but-for causation. What they said is that RWE has cumulatively contributed to increasing the risks of the flooding, because the levels of the lake have increased eightfold in 40 years, and so they use this contribution analysis, which the court accepted. They didn't say that RWE has to be solely responsible for the damage, but they have contributed to the damage. And that cumulative causation has been a really interesting development, I think. And it's because of climate attribution or event attribution. It's really gained a lot of speed in the last 10 years. It's become much more precise. And so what climate scientists are able to do is they build what they call factual and counterfactual worlds. So they use observational models of weather, and they say, okay, this is the world that we live in with climate change, and this is what the world would have looked like without people in a counterfactual, hypothetical model without climate change. And they are able to then prove that this flood or this temperature increase was this number of times hotter. So the first attribution study was on the European heat wave in 2004, and they proved that climate change contributed 0.5% increase in Celsius, and then they can actually now prove the number of deaths that climate change contributed to. So it's really leaps and bounds, and there's a paper that came out last year which built on Heaty's work, which basically said we are able to attribute increases to global mean surface temperatures and sea level rise specifically to carbon majors. Carbon majors as a whole, but also we're able to drill down and specifically identify individual companies that are responsible for percentage increases in temperature and sea level rise. And so attribution science is really becoming much more sophisticated, and courts are now using attribution science and grappling with climate science, which before it was, courts just said, okay, it's a debate previously in the original sort of Kivalina cases, and they said, okay, we're going to cite like a magazine article which doubts climate change right next to peer review literature on science, climate science. And now I think the judiciary is becoming much more sophisticated because of these specific papers that have been published which are proving the contribution of corporations to climate change. So I think the judiciary is becoming much more sophisticated in terms of the science. So there are also a number of securities cases brought where attorney generals in specific states are actually looking at the disclosures that carbon majors made and saying, actually, this may have been a fraudulent disclosure. You basically have not disclosed the carbon bubble that you're sitting on. And so therefore, you're valuing your companies in terms of, being able to continue to explore and exploit fossil fuels as if there was no end to that. But actually, if, regulation becomes more strict, you're not going to be able to extract at that level, and therefore you're sitting on a carbon bubble, which means that your investors are not actually getting the value that they think they're getting from your company. Now, these have not always been that successful, but securities law is another avenue that I think is quite interesting that is being used for carbon majors. And just to be clear, carbon majors are fighting back, so they're trying to prevent these pieces of litigation from going forward, so they're not just passively being sued. But I think there are a number of legal avenues that are opening up against carbon majors, but they're not all successful. So there was a case against Exxon by employees in a pension fund, and they said, okay, you have bought Exxon stock for our employee pension fund. You bought $800 million of stock in Exxon knowing that it's actually probably overvalued, and so we're suing you as a fiduciary that you didn't carry out your fiduciary duties to us as holders of this stock in the pension fund. So basically, you should have not bought it. And they were unsuccessful this year in that case because the judge basically relied on something called market-efficient hypotheses, that the market knows everything, that the market absorbed the public information about climate change, and therefore that was magically included in the stock of these companies, even though a number of these companies are now writing down their stock significantly. So they were not successful in that, but I think it was an innovative case, and there will probably be more to follow in relation to fiduciary duties. In terms of group structures, I want to make one point that's not come up. Group structures are really difficult to access the parent company. So there's a long line of cases in the UK where you had a lot of asbestos miners in South Africa, for example, or communities around Shell Oil in Nigeria that have tried to sue the parent company in the UK. And recently there's been a case in 2018 for pollution against Shell by communities in Nigeria, not going after the Nigerian subsidiary, but going straight after the English parent company, which has all the money. And they were unsuccessful in this suit, but there was a really good dissent. And the reason they were unsuccessful is because the judge decided that the parent company was not in control enough of the subsidiaries' actions. And that's in relation to pollution, but it's important for climate change because if you look at the climate strategies of these companies, they're basically drafted at the parent level. And so basically having a manual that's drafted at the parent level is not enough to access the parent company. But it doesn't mean that the subsidiaries themselves can't be sued in different jurisdictions. There's some regulatory progress going on. So in the UK, the Department for Works and Pensions has, at the beginning of this year, specifically issued guidance for pension fund managers on their fiduciary duties in relation to climate change. So basically saying you must take into account climate risk when you are starting to make decisions about investments. And that's basically on the back of a report which was a contribution of the pensions associations in the UK and an NGO called Client Earth, which brings a lot of litigation. And so basically giving guidance for pension investors. And so the state in the UK is now taking this on. And the enterprise principles were published in this year, basically saying that there are legal obligations that are crystallizing for not just enterprises, so private companies, but also institutional investors around climate change. So basically saying you're now going to have to deal with, climate change in terms of taking that into account when you're making fiduciary decisions. So 2018 has been a really exciting year in terms of litigation and also guidance being issued. So it's an exciting turn of events. It's partly because of this guy, who's Mark Carney. He's actually Canadian, but he's now the governor of the Bank of England. And in 2015, right before the Paris Agreement, he gave a speech to insurers at Lloyd's of London, carving out what's called the tragedy of the horizons. So what he said is that the performance valuations of companies, these short-term 3-month returns, are out of sync with asset valuations, which are longer-term valuations of assets. And this tragedy of time horizons is creating a fiscal bubble. And in his speech, he said this has the potential to undermine the fiscal stability of the world, basically. So it was a groundbreaking speech in 2015, and on the back of that, he was instrumental. So Bloomberg is chairing the Task Force for Climate-Related Financial Disclosures, which is voluntary guidance for companies to basically say, this is my risk for climate change. And this is exciting because I think the TCFD reports are going to become standard industry guidance. And when you are a director in a company, when you're making decisions, you have to take into account industry guidance. And so this is now, I think, crystallized to the point where directors are now going to have to start considering this guidance and this disclosure, and obviously taking into account long-term risks of climate change to their companies and their companies' performance. And so I'm hoping this will really galvanize institutional investors for the transition. So Christina in the afternoon panel may be less enthusiastic than I am, but basically it's the money that's motivated or allowed these negative externalities, and I'm hoping it's the money through institutional investors that will create the shift in investment into clean energy that we need. So I remain slightly, cautiously optimistic. Thank you.
I have to tell you that I absolutely love the efficient market hypothesis. So, as my business students will find out shortly when we get to securities fraud. Our next speaker is Benjamin Crass, who is a lawyer with Hagens, Berman, LP in Boston, Massachusetts, where he has over a decade of environmental litigation experience. So welcome, Benjamin. Thank you.
I might just need the same technical assistance here. Thanks for having me. Again, my name is Ben Crass, and I'm a litigator at Hagens, Berman, Sobel, Shapiro, a national law firm based in Seattle, and I'm out of the Boston office. One disclaimer before I get into the substance: I'm here in my personal capacity and expressing opinions that are my own in this academic discussion, and I'm not representing the views of any of my clients. So we represent the municipalities of Oakland, the city and county of San Francisco, New York City, and King County in Washington in climate change litigation. In each case, we've sued 5 major carbon producers: Chevron, ConocoPhillips, Exxon, BP, and Shell. Why? Because we're alleging that they are quantitatively and qualitatively different than other producers. Quantitatively, as Lisa went through with Mr. Heady's analysis, they are the 5 largest investor-owned fossil fuel producers by virtue of their historic production of fossil fuels. Qualitatively, they had early knowledge of climate change risks, knew things internally, and said other things externally to promote the pervasive use of their fossil fuels. And it's that qualitative part that I want to go through with you to show you some of the documents that have become available over the past couple of years due to several investigative news outlets. So these were not discovery documents, but these were documents that were dug up by investigative journalists over the past couple of years. In 1980, a scientist came to the American Petroleum Institute, which is the trade association for the fossil fuel companies, and gave a presentation. And this is what he said in 1980 internally to the companies about the likely impacts of climate change. Looking at the bottom bullet point, a 1 degree C rise by 2005, barely noticeable. That was an underestimate. By 2038, a 2.5 degree C rise. Major economic consequences, strong regional dependence. And by 2067, a 5 degree C rise with globally catastrophic effects. This is what the API scientist that they hired was telling API member companies, including the fossil fuel companies that we have sued back in 1980. This is a document from a 1978 Exxon internal presentation. I wanted to show you the cover page because it says that it's been presented to the Exxon Corporation Management Committee, so upper levels at Exxon. What were they told by Exxon scientists? Man can afford a 5 to 10 year time window to establish what must be done. This was back in 1978. And it is premature to limit the use of fossil fuels, but they should not be encouraged. A 1982 Exxon internal memo from one of their scientists. This is what they were telling them internally about the state of the science. Quote, over the past several years, a clear scientific consensus has emerged regarding the expected climatic effects of increased atmospheric CO2. The consensus is that a doubling of atmospheric CO2 from its pre-industrial revolution value would result in an average global temperature rise of 3 plus or minus 1.5 degrees C. And that is still the state of the science today. And then the last section, there is unanimous agreement in the scientific community that a temperature increase of this magnitude would bring about significant changes in the Earth's climate, including rainfall distribution and alterations in the biosphere. And the lawsuits allege that, in contrast to what Exxon scientists were telling it internally, over the next several decades, Exxon and other fossil fuel producers, in fact, were saying the complete opposite to the public, emphasizing the uncertainties and saying that no, there actually wasn't a problem. Another 1982 Exxon internal memo, given wide circulation to Exxon management, however, it should be restricted to Exxon personnel and not distributed externally. Oops. In this memo, an Exxon scientist says, mitigation of the greenhouse effect would require major reductions in fossil fuel combustion, 1982. What else was Exxon scientists telling it internally in 1982? You'll see this is the second use of the word catastrophic. In addition to the effects of climate on global agriculture, there are some potentially catastrophic events that must be considered. For example, if the Antarctic ice sheet, which is anchored on land, should melt, then this could cause a rise in sea level on the order of 5 meters. Such a rise would cause flooding on much of the U.S. East Coast, including the state of Florida and Washington, D.C. This is also from a 1982 Exxon internal memo. This is a very interesting slide. The bottom arrow you can see shows the range of natural fluctuations, and then the upper trajectory shows what happens when you add man-made emissions of CO2. And so you can see back in 1982 that Exxon internally was recognizing that there was a departure from the natural fluctuations. This is a chart from a recent IPCC, International Panel on Climate Change, the preeminent worldwide body in climate science, basically showing the same thing. And it's interesting how close the 1982 Exxon internal chart is to this chart, which shows the blue line is natural fluctuations, and then the red line is where we're going because of human fossil fuel production. There were also recently internal documents disclosed from Shell. This is a 1988 Shell internal report. And this is what Shell scientists were telling it in 1988. It is generally accepted that the increasing concentration of CO2 in the atmosphere is primarily determined by the combustion of fossil fuels. That's part of the causation story. This is a production problem. We've sued the defendants as producers of fossil fuels, not as emitters, as some of the prior global warming cases have done that went after electric utilities. So we're suing them in their role as manufacturers and producers. What else does the internal Shell 1988 report say? An overall reduction in fossil fuel use would, of course, reduce CO2 production, and some of the implications for the Shell companies changing demand for our products. So Shell was recognizing back in 1988 that this was a production of product issue. One of the common refrains you hear from the oil companies in court papers is that everybody expels and breathes CO2 and that therefore everybody is responsible. We have alleged, based on this and other evidence, that the defendants are qualitative and quantitatively different. Again, same 1988 Shell internal report. Mathematical models of the Earth's climate indicate that if this warming occurs, then it could create significant changes in sea level, ocean currents, precipitation patterns, regional temperature, and weather. These changes could be larger than any that have occurred over the past 12,000 years. Such relatively fast and dramatic changes would impact on the human environment, future living standards and food supplies, and could have major social, economic, and political consequences. The changes may be the greatest in recorded history. They could alter the environment in such a way that habitability would become more suitable in the one area and less suitable in the other. What that means is some places might become uninhabitable. Adaptation, migration, and replacement could be called for. All these actions will be costly and uncertain, but could be made acceptable. I want to show you one last Shell document. This is a Shell Group Scenarios document, and this is basically a document where they put out possible future scenarios and then, what would be their reaction to it. So under one of these scenarios, they posit this. In 2010, a series of violent storms causes extensive damage to the eastern coast of the U.S. Although it is not clear whether the storms are caused by climate change, people are not willing to take further chances. The insurance industry refuses to accept liability, setting off a fierce debate over who is liable, the insurance industry or the government. After all, 2 successive IPCC, that's the worldwide scientific body, reports since 1995 had reinforced the human connection to climate change. Here's the scenario they were positing sometime before 1998. Following the storms, a coalition of environmental NGOs brings a class action suit against the U.S. government and fossil fuel companies on the grounds of neglecting what scientists, including their own, have been saying for years, that something must be done. They were close. There hasn't been a class action lawsuit brought, but there have now been lawsuits brought about climate change. So I just wanted to share some of the internal documents from the companies. So you didn't need to believe me necessarily, but you can believe them because that's what they were saying internally. The cases, just to give you a little bit more detail about the cases, the Oakland and the San Francisco case were brought in state court in California. The defendants removed it to federal court on a number of bases. The federal court accepted jurisdiction and ended up dismissing the claims. We're now on appeal in the Ninth Circuit. And the New York City case was brought in federal court in Manhattan and New York. That case was also dismissed, and we are on appeal in the Second Circuit. And then the King County case is pending in federal court in Washington. And I should mention that those are four of probably between 10 and 15 different climate change lawsuits that are currently pending in state court. Our primary claim is public nuisance under state law. Public nuisance is simply an unreasonable interference with a right common to the public good. And Lisa had mentioned causation. The key thing for a public nuisance is all you need to do is contribute. So we don't need to show that each company by itself caused climate change. That's not required under public nuisance law. And we think that we've alleged, and we think we can show that these companies, through their massive production over decades and their early internal knowledge about the climate science and the likely impacts, including that they may be catastrophic, and the fact that they've continued to promote and produce massive amounts of fossil fuels over the ensuing decades shows that they've contributed to our clients' climate change injuries. So thank you very much, and I look forward to your questions.
Thank you. In fact, my torch students in a couple of weeks will start looking at public nuisance. So, Brian, pleasure to have you with us this morning. It was good to see you. Thank you so much.
Thank you. Thank you. So, thank you. It's great to be here. I always I'm from Burlington, and it's about an hour and a half to get down here, and I always. It's always hard to leave Burlington to get down to the law school, but I try to do it a couple times a month, and I never regret it afterwards, and I'm sure today will be no different. Mark has, let's see how quickly my presentation goes off the rails. Mark didn't say anything about what I'm going to talk about because he doesn't know, and I didn't know what anyone else was going to talk about. I did have the benefit of a very capable paralegal, Julian Bergeron, put together some slides for me as I was driving down. And after talking with the students last night and this morning, I'm not going to talk about the presentation I thought I was going to talk about either. So here we go. After talking with the students on the law review and some others this morning, what I realize is, while you're sitting here at law school, it's, I'm sure, intellectually engaging, but you're also wondering, well, what am I going to do with this degree or degrees when I get out? And so what I'd like to do is kind of take some inspiration from those conversations I was having and talk with you a little bit about 3 different perspectives I've had throughout my career on working on climate change, and particularly working on climate change from the vis-a-vis corporations. The first perspective I'll talk about is from the outside, being an advocate and litigator for a national nonprofit organization. The second will be from a lawyer who is invited inside, but you're still outside. And then the third is from inside as the corporation's business counsel or risk counsel. So from the outside, my first job at a law school, and I want to mention this because it just, this will come up with the last slide that I will use. I was hired for National Environmental Group, Friends of the Earth. Didn't really know what I was going to be doing. Actually, I'm trying to think. I moved down to DC and immediately started working on legislation that had recently failed but was trying to get rebooted to pass a federal carbon tax. Believe it or not, the United States Senate almost passed a federal carbon tax. This was during the first term of the Clinton administration. And I had taken a couple of courses with Janet Milne, professor here, and apparently that qualified me to help work on federal tax legislation. It failed, it never came back, and there's really no prospects of federal carbon tax in the foreseeable future as far as I can see, and I guess I would be interested if anyone disagrees with that. What I eventually got to work on is developing a series of lawsuits that focused on federal government subsidies that basically subsidized the release of greenhouse gas emissions. Some of these cases involved how leases and licenses were allowed on federal public lands, Department of Interior managed lands, U.S. Forest Service lands. But I had a decent-sized budget, and my client, the president of Friends of the Earth, worked with lots of economists, and he said, there's these two federal agencies that no one has really ever heard about that I swear are subsidizing greenhouse gas emissions like no one else. And so the first thing we did is assemble, well, let me take a step back. In preparing these cases, what I realized was, we needed to make cases that were relatively simple, had really strong facts, and were able to beat a motion to dismiss. Essentially, if you can't beat a motion to dismiss, you never get to the substance. And so a lot of what I was doing was working to design for those benefits. The other thing was, this was in 2002, this was in like 1998 when I started this work. People just didn't really believe that climate change was real. People didn't believe that the impacts were real. And so we worked with people in communications to figure out how do we take the science to tell compelling facts that will make for great stories. So the first thing that we did was we looked at these two federal agencies, the Overseas Private Investment Corporation and the Export-Import Bank, looked at the fact that over about 6 years, they were financing fossil fuel projects at about $32 billion. And then we said, okay, how much direct and indirect fossil fuels would be released due to this financing? And I went out and looked for an expert, and the expert I found was Richard Heedy, who was in that barn that he was standing out in front. And we said, look, can you perform this carbon accounting? And this was before all of his papers, really before. And he's like, yes, I can do that. And so he did that work for us, and is this gonna work? And over really a 2-year period working with him, we got to this one fact that was really important, that these two federal agencies nearly account for 8% of the world's emissions, and the equivalent of 1/3 of U.S. carbon emissions. And with that fact, we said we are going to make this case, figure out a way to make this fact allow this case to beat a motion to dismiss, because we knew that the federal government was going to file a motion to dismiss for lack of standing. And I guess what I want to emphasize is that, this is an excerpt from an affidavit that we filed in federal court in San Francisco to support that our clients had standing. And but there are just reams of essentially Excel sheets and accounting work that went into that text narrative. And so, working on the facts really matter. And this was back in 2002, and what I heard, from Dr. Benjamin and Ben was, the work of Rick Heady has continued on through the next 25 years, and it was really the start of that. And so that's really remarkable and important to me. The other piece of this was, we didn't know whether we were going to beat a motion to dismiss, but we said, win or lose, we want to make sure we tell a really good story. And we felt that the work that was coming out of the US EPA that fed into the climate negotiations told a really good story that the public would be interested in hearing about the injuries caused by climate change. And so we essentially worked to build our plaintiffs to be able to tell that story about those injuries. So the first thing we did is we went out and worked on convincing cities to join us as plaintiffs in these cases. Obviously, a strategy that continues today. We went and talked, Vermont Superior Court, and this is where sort of, you can't plan this stuff out. Vermont Superior Court Judge Tor, her younger brother was the mayor of was the mayor of Boulder, Colorado. She helped me get introduced to him. Boulder, Colorado became a client in the case. Now Governor Jerry Brown was the mayor of Oakland, California. He became a client in the case. And so telling the story about the budget implications that the cities were occurring back in 2002 due to making changes to infrastructure. It's really the same thing as the farmer and needing to make changes to the dam. I mean, that is exactly what the mayor of Oakland was dealing with in terms of how to keep the Oakland airport's runways above water. The other success of this approach was we had Maverick Farm that's here in Sharon, Vermont, Maple Sugar Farm. They were a plaintiff in the case. The national media attention that this farmer suing these two federal agencies got resulted in, it was either Good Morning America or the Today Show, shot a fall foliage morning show at Maverick Farm in Sharon, Vermont, riding around with Arthur Burton, who I believe his son-in-law is a VLS grad, riding around on his tractor around Sharon, looking at the sugar maples, explaining the science of how he's concerned that his tree saplings aren't surviving at the rate that they had for decades prior. And so using the sort of impact litigation to tell the story is a benefit, win or lose. And it also makes litigating a lot more interesting in my experience. The result of that case was that we ended up settling because despite best efforts, litigation always gets more complicated. I thought I had a really simple case. It was a NEPA case. I filed a FOIA request. The two federal agencies responded in this way. We said, tell us about all your NEPA documentation for this $32 billion in financing. And they basically said, we have no documents in response to your request. So I thought I had a really simple substantive legal case. It got really complicated really fast after the motion to dismiss. Essentially, the judge said, okay, we want you to put on a mini trial for every decision that led to the spending of that $32 billion, which was something obviously no one had time to do. So we settled the case. There was basically a $500 million financing of renewable energy projects and an agreement to comply with NEPA. The next kind of area I want to talk on, and I'm running out of time. This is where I run off the rails. I had my firm had the opportunity. We worked for a private foundation with connections to insurance companies and advisors to insurance companies. We wrote a white paper. This is back in 2003. We wrote a white paper on legal litigation risk for insurance companies, and then got invited into the boardrooms for some of these insurance companies to advise them on what we saw the potential for litigation risk. I'm not sure whether they listened to us, but this slide was not available back in 2003, but it's the 2017 $1 billion climate disasters put out by, this is a NOAA document, so the federal government still more or less producing some useful information. And then the last kind of perspective I wanted to touch on was the kind of being on the inside. And here, several of my clients started out as inventors or innovators, just small startups. And then if they do their job well and are successful, and as a lawyer, you do your job well and are successful, they often get acquired. And then sometimes when they get acquired, you just get bought up by bigger and bigger. I have had the privilege of working with Seventh Generation, which is a Burlington-based company, for about 18 years. 3 years ago, they were purchased by Unilever, and the influence that you can have from the inside, I could say unequivocally that the benefit of the decisions that my clients make with regards to greenhouse gas emissions far outweigh any of my impact litigation time. The influence you could have on the inside is incredible. I remember the point I want to make is when I went to law school, I could not envision that I would want to work for a corporation. And my notion around that was very wrong for me. I think I serve my clients who are businesses a lot better, having had the time and experience as a litigator. But the influence that you can have inside is really shouldn't be discounted. So Unilever does lots of good stuff. I could talk with you about it later. They're buying lots of good companies because they know that those companies are more profitable. Of Unilever's sort of sustainable living brands, they outperform their other brands by 47%. So they're going to keep on buying those types of companies, which means that there are job prospects for working for those types of companies for you. And this is what I wanted to get to before my time ran out, which is, so this is a quote from the CEO of Seventh Generation, where for the past several years I've been able to work with them. They've instituted an internal carbon tax. So essentially what they are doing is charging a premium on all of their carbon emissions, and then they're allocating that revenue to either avoid those emissions in the first place, or make investments to displace those emissions, and that's the type of change that businesses can do voluntarily. When it happens for a company that's owned by a large multinational corporation like Unilever, that has the promise of being replicated if it works. And with that, I'll conclude. Thanks.
So apparently, Unilever really likes Vermont companies because they acquired Ben & Jerry's years ago, and now they acquired Seventh Generation. But as a follow-up to Brian's point about working for corporations, which I did a fair amount of when I was in law practice. What I tell students who are interested is, in forcing corporations to make change is that you've got to make the business case, right? Because at the end of the day, as was alluded to by Lisa, businesses, or at least publicly traded ones, are about increasing shareholder value. And so if you want to drive some other change at the corporate level, you have to make the business case, which has been done nicely with the business such as 7th Generation and Ben & Jerry's. So now we're at a point where we're going to take questions. Are there mics that we have? Okay. So if you'd state your name and use the microphone, then our panelists, and let's thank them again. Thank you all.
Thanks. Hi, Victor Flatt. Got to meet you guys, some of you last night. Is that on?
I think it's on.
Okay. Great. Great panel, and it reminds me that I think all our panels are going to overlap in a lot of ways, bad things, how they can be turned into good things, et cetera. Benjamin, I had a question for you. I sort of feel like you were on the call that Patrick Parenteau and Ann Carlson maybe organized about this litigation, maybe not. But you mentioned you're in federal court. Don't you all want to be in state court? And how are you trying to make sure you get to stay in state court?
So I don't think I was on the call with Pat, but in terms of the cases, so yes, we did, the Oakland and San Francisco cases were filed in state court. State courts traditionally adjudicate state law claims, which is what we brought in every case. The defendants argued that based on Mass v. EPA and on the Connecticut versus AEP case, that the only kind of climate change claim that exists, if it exists at all, and they don't think it does, but if it does, that it's a federal common law claim. And so that's why the federal court grabbed the case and denied our motion to remand. There was a different judge in San Francisco federal court in different cases, climate change cases brought by other California municipalities, that did grant the motion to remand. That decision is on appeal to the Ninth Circuit by the defendants, but at least one judge has said no, these are state law claims that belong in state court. The King County and the New York City cases were brought in federal court because there was diversity jurisdiction with the defendants that were sued. So I think traditionally, plaintiffs' lawyers want to be in state court because state law public nuisance is a very long-standing and traditional state law claim that state courts have a lot of experience adjudicating.
Thank you. As a follow-up, I think it's Judge Alsop in the Northern District of California. He did an interesting thing in terms of becoming educated about climate change science. Would you talk about that?
Sure, and Lisa did mention that, from her perspective, judges are becoming more comfortable with climate change science and more accepting. I did want to mention that I did work on a case in Vermont federal court a number of years ago, back in 2006. It was one of the Pavley cases. The automakers had sued Vermont to strike down Vermont's greenhouse gas regulation for automobile tailpipe emissions. And we did put on climate change science in that case. We put on Dr. Hansen from NASA as a witness. And the court was very accepting of the climate change science. And that was back in 2006. But in the San Francisco and Oakland cases, it was actually pretty interesting. Once the case got removed, Judge Alsop in federal court in San Francisco ordered the parties to appear for a 4-hour climate change tutorial. And he wanted the parties to address a laundry list of climate change science questions. And so the defendants got 2 hours to present. Our side got 2 hours to present. We put on several scientists about the causes of climate change, the impacts, and the long and the short of it was, from the court's perspective, he said basically the parties agree about climate change science. That was his perspective, and he required the defendants basically to say, do you accept today climate change science? And I think the answer was, it was qualified, but it was generally yes, and the court interpreted it as climate change science, at least for purposes of today, and this case was settled. And so that's another, I guess, example of courts becoming pretty comfortable with the climate change science, and the fight is less about climate change science and more about who's responsible to pay for the impacts.
Victor, I just want to add, I know that you went back to Houston from North Carolina about a year ago, and I hope that all your friends and former colleagues at Chapel Hill are going to do well over the next few days with Hurricane Florence. So they're with us in our thoughts. Other questions? Yeah.
Thanks for a great panel. That was awesome to hear everyone speak. So something that stuck out, Brian, was something that you'd said about how it's highly unlikely that we'd ever get a carbon tax, which I have to say I agree with you because national politics are a little crazy. But I know some state, like public service commissions, are thinking about carbon pricing. I know there are two different things, but I think they might kind of get at bringing in that externality as well. So I was just wondering what anyone thinks about that idea, if it could be just as effective, more effective, or less effective, carbon pricing.
What's the tackle?
Directed at you, so I'll give you the first crack.
Well, I guess over the years, the carbon tax legislation proposals come up. I think there's actually a live proposal in Vermont right now. It's kind of viewed as a third rail, particularly for a Democratic candidate to have to get behind. But politics aside, we've looked at moving legislation. My clients have looked at moving legislation, as attempting to monetize the externalities and calling it something else. We've looked at ways to do that through the Public Service Board, now the PUC. We've looked at legislation. You know, I guess the main point I wanted to make is whether it's litigation or legislation, there's a degree of uncertainty involved, whereas businesses are generally appreciate certainty. And if you're able to align with what the business's constituents want, whether it's employees, whether it's customers, consumers, then you could work with your business, you know, like to attempt to align the business's actions with, you know, taking positive steps to reduce greenhouse gas emissions. And one of the things I wanted to point out is that, you know, Unilever, I don't know what motivates Unilever. I do know that they rely on data. I know that they rely on data about consumers and potential consumers. One of the data points that I just kind of blew by was the fact that they completed a consumer preference study in 2017 of 20,000 consumers. They saw that about a third of those consumers wanted to know about the climate change performance about the products they purchased. And so I kind of saw that data and said, 23%, that's a, you know, how terrible. Like only 23% of potential consumers care. But, you know, I'm assuming what Unilever saw was that, well, you know, the market that these types of brands occupy, the percentage of the market that these types of brands occupy is about 3%, maybe even less. So there's, you know, 20% of the consumers that are inclined who, you know, don't have access to the brands that they would want, and that's kind of, you know, what's moving the needle.
Do you want to add anything?
A lot. I want to add a lot. I have to start by saying I hadn't thought about before the mechanism of an internal carbon pricing, and I think the point is well taken. That could be really powerful. I mean, that I think illustrates the sort of systemic change that you'd be seeking in trying to externalize these costs. But I am, amongst tree huggers, probably the rare skeptic on carbon pricing at the moment. I'm looking at some of the coalitions that are being formed that have, you know, remarkable diversity. You see oil companies pairing up with people like Laureen Powell Jobs and hiring Trent Lott to go and lobby for carbon pricing. And I'm looking for the sort of evil that lurks behind the curtain. And the evil that I see there is that we may end up using this as a way to extend the current business model, the current business as usual, longer, as opposed to using it as a way to really, rapidly accelerate. By 2020, we heard earlier, right? Rapidly accelerate change. Sure. Yeah.
I think we might think alike. And the legislative fights I've seen, the devil is always in, well, what do you do with the revenue raised? And those coalitions sometimes are built around, well, the carbon tax is regressive, so we need to do use the money in a progressive way. But it's the legislature, and they'll have more money, and how do you know how it will be used? And again, that internal approach, that's what's really exciting to me about it.
We are indeed brothers in arms. The other thing that we talk about using this revenue for, if it's not going to be returned to deal with regressive issues, is to pay for adaptation efforts. And I worry about whether there's the political will to have a carbon price that's ever high enough to deal with that true cost. I also think that the sort of best science today on carbon pricing and the externalities, it's always forward-looking, as opposed to thinking about what we really are trying to adjust in an adaptation sense is the historical obligation. So Angela, the answer to your question is, I'm a skeptic, but I'm hopeful. I think smart people are thinking about these issues.
I just wanted to chime in on the carbon tax again. We had a University of Houston and Duke had a sort of a confab about revisiting taxation and cap and trade and what are the likelihoods and the political barriers, et cetera. And you all have already sort of mentioned this, but some conservative groups, particularly the Baker-Schultz proposal, is a fairly realistic one in terms of carbon taxation. It starts at $40 a ton and it actually ratchets up past $100 a ton. It would be set in place. And of course, for them, the money would have to go directly back to the consumer, so you wouldn't spend it for anything. But the thing I think, and I'd love to hear your comments on this, that the conservative folks that are pushing for the carbon tax are also pushing for complete preemption of state and federal litigation as the trade-off. And that presents a different kind of a political blockage. What are your thoughts about and yet it seems like the litigation is what's pushing certain conservative groups to actually embrace the potential for the carbon tax?
I'm afraid of more than just that. I think it's preemption of the litigation issues. There's also, tied to that particular proposal, rolling back state-level greenhouse gas emission targets and sort of the real fundamental, to this date, drivers of the progress we have made. It scares me.
I'm not going to comment on the policy or the substance because I really don't know anything about it. But 2 points. You mentioned the filing of the litigation and then businesses or conservative interests reacting to it. And that I want to bring home to being a practitioner. And if you are inside, whether you're in-house counsel or outside counsel, and you're advising decision makers, you will be asked, what is the risk presented either by this litigation because we were sued, or what is the risk of us getting sued for a case like this one, that hit someone else in the industry? And your ability as a lawyer to bring information so that businesses can make decisions that make sense for them, that is really one of the most rewarding aspects of being a lawyer, kind of taking risk, putting it into buckets, and then allowing someone else to make a decision. So, the cases that Ben and his law firm file, whether they're successful or not, they are influencing business in one way or another.
Report or effort. I was astonished that here 2 Republicans were lobbying for a carbon tax, but then you get to the devil's in the details, and what the quid pro quo is then they're seeking immunity from state and federal lawsuits for prior emissions, and I'm just not sure that that the $40 a ton is the right price, but also I'm not sure the immunity is worth it. But in any event, go ahead.
All right, hi everybody. My name is Chad. I have a question as it relates to corporations. I noticed a lot of people saying that, corporations have to institute all these changes, and I tend to agree with you for sure. But here's the problem. I mean, if a corporation is responsible to its shareholders, which is pretty much what it is what it is at this point. And so if the CEO embraces changes that are going to lose the shareholders' money, the CEO is just going to get replaced. I mean, over and over and over again. That's how it works. And, I just wonder what your response was to that, how you think you change the corporate culture, notwithstanding, like, companies that actually embrace, these changes, but let's be real, most of them don't. And so it's just going to keep overturning the CEO every time if they're losing money. And I mean, what do you say to that?
I think just to piggyback on the comment that was made before, the narrative has changed from the impacts that corporations are having on the environment to almost the reverse. What's the risk of climate change to this corporation? And so if you remove, so there's lots of different risks. There's physical risk, but there's also transition risk to transitioning to new energy sources, and then regulatory risks. So litigation is part of that risk metric that directors will look at, and if that's removed, then that is a big leg of the incentive to transition. And so to your question, I think the exciting part of this is the actual institutional investors who are shareholders. So when you have really big institutional investors who are savvy enough to realize the risk to their investment of climate change is huge, and they then start putting pressure on the CEOs and the board to say, are you calculating what this risk will cost us long term? So first of all, you need long-term investors, and that is a problem. There's a lot of exit and buying and selling on the market. So there's short-termism that is there. But the long-term investors who are really looking, and pension funds is a great example of that. They're supposed to be long-term investors because you're supposed to be investing for when you get old, and you'll have money to support you when you get old. So big institutional investors like BlackRock are thinking about these issues, and when they start looking at the numbers of the risk to their portfolios, and institutional investors are universal shareholders. That's the theory. They hold shares in lots of different companies. And so if you have what Mark Carney has described as a tremendous fiscal instability caused by climate change, that is across the board, across all of your portfolios, that means that the transition, first of all, there's two parts to his thesis. First of all, the transition cannot be too stark because you will basically undercut the value of these shares tomorrow. So he's talking about a gradual, not slow, a gradual transition, which doesn't always work with the science. And then second of all, the part of his thesis is that there has to be a transition because we cannot let this bubble grow and grow and grow without having some realistic method to work through it. So I think when you start to see savvy shareholders and investors saying, we understand the risk, we understand this is a massive risk and we have to transition, that is, I think, what will put the pressure on directors because they are supposed to, in theory, answer to their shareholders for profits. So you need sort of the divestment and reinvestment into clean energy, and that is the transition. So the timing of it, I think, is the difficult part.
I'm not sure I agree with the proposition that that becoming more sustainable as a business will necessarily lead to a loss of value for shareholders. Because I think the business case can be made today that move may actually increase your value to shareholders of the company. And in fact, about 5-6 years ago, Colbert, Kravis, and Roberts, for those of you who know who they are, that's one of the top private equity firms in the nation. And they were involved in a controversial transaction to acquire TXU, a bunch of coal-fired utilities in Texas. And EDF and others challenged that. And eventually, they worked together with EDF, who said, look, we'll come in and work with some of your portfolio companies, and we will reduce the amount of waste and therefore increase your profits. And they did that over a year period. So I'm not sure I buy the proposition that just because you're attempting change in a more sustainable direction as a business, that would necessarily lead to losses. And to one other thing, a lot of state corporation laws do allow the board of directors to take into account other constituents besides shareholders. So
I would want to emphasize Mark's point also in terms of that either or choice. I don't think it's really not even what's being taught in business school today. And just going back again to the example of Unilever, they bought Ben & Jerry's about 20 years ago. They've built a portfolio of sustainable living brands with about 26 brands in it right now. Seventh Generation is one of those 26 brands. They are buying those brands at the pace they're buying them because they're outperforming their conventional brands. And they're buying them not because they have great market share or incredibly high profitability today. They're buying them because of their intellectual know-how, knowing how to run a business sustainably while still making returns or having the promise of making returns. And what they're doing is they're taking it. It was the 1980s film Wall Street, with the corporate raiders. What's happening today is a multinational will come in, buy a company with that sort of sustainable living know-how, and then take that expertise and bring it to their other conventional brands and say, environmental chemist, formulate the way you are formulating there for this other conventional brand. And that's how systemic change happens. Whether it's motivated because of institutional investors or otherwise, that I don't know the answer to that. But that's what I'm seeing happening.
May I 20 seconds? Yes. Just a plug for securities laws in response to your question. We might also think about what's the impact of the quarterly disclosure rules and how does that play into some of the shorter term thinking that is, I think, the old way of thinking. In the modern world, the digital age, the efficient market doesn't need quarterly written disclosures. We could do it in different ways. So we might rethink the whole playing field could change if we changed corporate governance through the securities laws, which would, I think, reinforce all of these other mechanisms that have been described.
Be a question of clarification for over here, right in the middle, mostly for Mr. Walsgrove, concerning the securitization. I just wanted to know, because I really want to understand, is the basic premise behind what you were saying about securitization essentially that if the SEC and other state financial regulation authorities classify the activities of community solar as a security, will that make it cost preventative for smaller financial entities such as community initiatives?
I think that's 90% of the way there. It is the uncertainty and the big thorny legal questions that come up that actually acts as the barrier. Actually, I think if we had certainty one way or the other, the innovative business models could probably figure it out, but we have this crippling uncertainty. And then I would say I'm adding one additional layer to the onion, which is let's think about how this question has come up. I think your question was asked in a very rational, business-minded way, but is this really being used as a sword, which is not what the securities laws are all about?
Sure. Well, I guess as a follow-up to that, I personally, and I don't claim to be an expert at all, feel like financial incentive is going to drive the transformation of our energy sector towards something that actually serves humanity well. But on the other side of the equal sign from what you were saying, could there possibly be advantage to securitization as that brings in money and business interests? I guess that's essentially what you were just saying. But I know that you said that you were pushing for these activities to be not classified as securities. But could there be an advantage to classifying as securities in order to bring about the kind of capital that might, accelerate the ability for businesses to look at installing alternative energy sources like community solar as more profitable and thereby do it more expediently?
The $1 trillion value of the New York Stock Exchange says the answer to your question is yes. That the securities laws have created a realm in which we're all comfortable in investing in the way that the stock exchange allows us to do it. I guess my question is whether or not some of these other models, whether these smaller emerging models, whether they're consistent with that particular market type. And so the idea that, the most cost-effective energy resource will win, and so if we externalize the costs, problem goes away. We just have to recognize that cost-effectiveness is influenced by so many different things, and this being just one of them for that particular type of energy, that the question becomes almost irreducibly complex immediately in the modern age.
Professor Scanlon.
Thanks. This has been an interesting conversation. I want to go back to the business case for sustainability. And I think that I agree with what's been said as it relates to Unilever and those types of businesses. But what do you do with fossil fuel companies where they really have about $1 trillion of assets potentially that need to stay in the ground? And what is the business case for sustainability for those companies? And if there is none, what is the solution for that? And I think I'm using that as a leapfrog for us, because the afternoon is going to be even more focused on solutions. But I'd love to hear your opinions on that.
Don't look at me.
So,
Actually, I have some thoughts.
Again, just from the perspective of a practitioner, we do a lot of work for the permitting of and financing of renewable energy projects. When we first started doing that work in the late 1990s, a lot of our clients were individuals, small startups. Those entities who have been successful have been purchased. And then those entities that were purchased have been purchased and purchased again. So now the vast majority of my clients that are doing the most work are an entity, usually an entity that holds renewable energy assets, but its parent company owns a slew of other assets that are most likely carbon-based assets. And again, for me, it comes down to the same equation and calculation that apparently someone at Unilever made, which is where will the capital go for that organization, and what's outperforming what. Now, you need to get the policy right? Because we know that the subsidies are I guess there's broad debate about where the subsidies are going, but the data I've seen shows that the release of greenhouse gas emissions are still highly subsidized. So you can't leave the policy question off the table.
I mean, this is the area that I look at. It's extremely difficult, and basically the return values on their reserves. So there's some work done by Heedy and Naomi Oretsky, and they've looked at sort of the reserves that these companies have and how they're being valued, and they're being valued at the same rate as if climate change didn't exist, and that's just wrong. And so there are some difficult issues to face with these companies. Either they transition out of existence, which they're not willing to do. They've known for a long time, and they're trying to spin out profits for as long as they can using the same model. There are other theories that they have well-equipped research and development. They have good scientists. They have talented employees. All of that human capital could be used to transition to a renewable energy company. So that's a different theory. The other theory is that they are paid to transition. So you pay them out of their existing models. And the other approach is you regulate it. You regulate it so that you can no longer at the federal level have emissions like that, and that's just not going to happen anytime soon. And so then you rely on subnational actors like California, and even private industries who will move to, say, a Google will move to a state to say, I will move here if you provide renewables. So there are different approaches to this. None of them are easy. None of them may happen in the near future. But I think that's why I'm really hanging my hopes on institutional investors. It may be a false hope, but I think the risk piece of it is growing in importance. And if you can have the risk be clear enough that people understand the economic case for transitioning out of these companies and into renewables, and then of course you have sort of the price of renewables, which is falling dramatically, largely because of China's manufacturing capacity in renewables. So there are economic arguments for transitioning, but these companies are intractable problems, and there's no easy answer of how to deal with them.
Yeah, and I think too, they're a great example, I think, of market failure, right? Because under the efficient market hypothesis, all this bad news about climate change, one would think would drive down their share prices. That's not really happened. So what do you do about that? And I think that's where the government has to step in and regulate when we have a major market failure like carbon emissions. But unfortunately, that's not going to happen anytime soon. And another thing too, I think that can be brought to bear is public pressure. As the challenges with climate change become more acute, I think individuals, including myself and my gas-guzzling little sports car, need to rethink that and really put pressure on these businesses so that they'll change their business model and start leaving carbon in the ground where it belongs. So,
Can I just thinking about that initial case I talked about against OPIC and XM, Lisa, we looked at a decision that's made by USGS that goes at whether or not gas reserves and coal reserves are accessible, and then they do a calculation that determines, whether a reserve is financially accessible, which I think leads to the valuation of these reserves that go on balance sheets. And so that USGS decision, which occurs fairly regularly, is actually not subject to NEPA review. They have it as, one of those categories of decisions that have no impact on the environment. And so, one case that I've thought about was, can we sue USGS on how they make that decision and make them do an EIS on that decision before they make it? Because there's got to be variables. There must be alternatives on how they calculate whether reserves are accessible.
Professor Scanlon, if I could also respond, because it's a question obviously lots of us are interested in. I'm lucky I don't have to talk about the difficulty of the problem. I think that was far more eloquently stated. But if I started to describe it in one sentence, it would be, well, the assumption resting there is that there are trillions of dollars worth of assets in the ground, and maybe they're not really worth trillions of dollars. Rather than trying to figure out how to do that, reduce the value of the assets, which I think smarter people than me are working on, I say let's use this as a way to think about prioritization. If I'm asked, for example, what's a better thing for me to invest in? Should I invest in wind and solar, or should I invest in direct air capture, which can create gasoline and pull CO2 out of the air? I'm skeptical of the direct air capture solution because it just continues business as usual. We're still using gasoline. And we need to recognize, I think, that it's sort of just a mind shift for us that nobody wants to buy gasoline. Not because of fossil fuels and CO2, but because we're not using the gasoline. We want the energy services. I want to get to work. I want a hot shower. So it's not the fossil fuels that are intrinsically valued, it's the what we get from it as consumers. And I think the more that becomes our mindset, the more we start to pick the smarter solutions just naturally and reinforce it with dealing with the externalities and those sorts of things.
I just want to drive fast. Time for one more question.
Okay. Hi, my name is Theo, and I had a question for Dr. Benjamin. My question concerns about corporate law, and you mentioned earlier that it's basically found a way to externalize all the negative impacts, and I'm wondering, and push it off onto other bodies of law, and I'm wondering, how did that come to be, and is there a way actually to change that?
I spent a couple of years thinking about this, so thank you for asking. It's that you're interested in it, as my thoughts didn't go to waste. I think there's been an evolution in the law. So if you think of the Dodge case v. Ford, there were some early cases that said, you know what, if you think about non-shareholders, their interests are valuable in corporations, and so you should start thinking about them. And then you had really a very powerful law and economic school of thought that developed this theory that's still really predominant today, that it's really shareholder interests that are predominant and non-shareholder interests are not predominant. But that's a sort of normative theory, but it's not always enshrined in the statutes, in corporate law statutes in different countries or different states. So I look primarily in the UK, and funnily enough, they did a big review about what's the purpose of corporate law, and they thought about taking a pluralistic view of looking at all the different stakeholders, and they said, well, that doesn't reflect reality. So they actually enshrined in their statute that shareholder interests are the first interest that you look at, and then you can look at other constituents after that. But really, once directors get to that first one, they're not really going to... The theory is that they can't balance all these different kinds of interests. But there are constituent statutes in different states, and so the law varies. But the norm of shareholder wealth maximization has become so powerful that most directors think that that is what they are supposed to do, even if the law doesn't mandate them to do that. And so the reason that I'm excited about the TCFD or other industry standards is that directors always have a fiduciary duty. And they have to look at what's happening in the law and what the industry standards are. And so, a couple of years ago, if you asked the average director about climate change, and maybe this is the case today, they really wouldn't have thought it would have to be part of their weighing considerations when they're thinking about their duties to the company. But now I think industry standards have evolved, and I think most savvy directors, if they, really consider their fiduciary duties broadly, they're going to have to take into industry guidance, which means they're going to have to figure out their disclosures about climate risk. They're going to have to actually start thinking about climate change in terms of their daily decisions and their duty to the company. So I'm hopeful that this litigation and also the industry guidance is going to start coloring fiduciary duties, that the directors have to start thinking about it. But yeah, shareholder wealth maximization is a norm, but it's extremely powerful.
And if we change that, Milton Friedman will roll around in his grave with and his head will explode. So, but thank you. We're unfortunately out of time, but thank you again for joining us. This was a terrific morning with you, so thanks much. Thank you.
All right, thanks again to panel one. That was fantastic. You got our day off to a great start. We are going to take a quick little break. We're going to feed our panelists and get them ready for the afternoon. So our afternoon session starts promptly at 12:45.